testify, and I will turn to Senator Hawley to introduce Mr. O'Brien.
Thank you very much, Mr. Chairman. It's a pleasure to introduce my friend Sean O'Brien as a witness this morning. He is the General President of the International Brotherhood of Teamsters. Many of you have heard Sean testify before this committee in the past, in past hearings, but I thought I might just say a word or two more about the man, a little bit more than perhaps his job title conveys. Sean is a fourth-generation Teamster. His great-grandfather immigrated from Ireland, landed in Boston, and made deliveries in a horse-drawn wagon. Sean's family didn't pass the wagon down through the generations, but they certainly preserved their great-grandfather's spirit. Sean's father was also a lifelong Teamster, as are two of his brothers. When he turned 18, Sean himself joined Teamsters Local 25 as a heavy equipment driver, and he has kept working ever since for himself and for his fellow working men and women. His dedication, I think, is undeniable, and so is the heart of the Teamsters. Just a few days ago, approximately 6,000 Teamster locomotive engineers ratified a new 5-year contract with Union Pacific. And just last month, 160 Teamster bus drivers, monitors, and mechanics in Michigan ratified their first union contract. I could go on all day with these examples. The point is, Sean O'Brien knows his fellow workers. He cares about their lives and their well-being, and he's here today to help us understand how we can better serve the American people. And I hope it's obvious to everybody on this committee that we've got work to do when it comes to the nation's labor market. Since the COVID-19 pandemic, corporate profits are up, employee wages are stagnant, and American workers don't just compete anymore with foreign labor, which is bad enough. Now they've got to contend with AI coming for their jobs. We know we've got to do more than we're doing now for our workers, and we've got to do more to update our labor laws, which haven't seen significant reform in over 40 years. I'm glad that Sean O'Brien is here today to help us talk about this important effort and what we can do to get a revival of the American worker. Thank you, Mr. Chairman. Thanks for being here, Mr. O'Brien.
Mr. O'Brien.
Cassidy, thank you. See, we're already working together. Should put my microphone on. Good morning, Chairman Cassidy, Ranking Member Sanders, members of the committee. My name is Sean O'Brien. I have the honor to serve as General President of the International Brotherhood of Teamsters. Thank you for the opportunity to join you today. This is the third time that I've appeared before this committee to talk about our nation's weak, unenforceable labor laws. Under both Democratic and Republican committee chairs, we have identified problems and had the same discussions, but have seen zero solutions enacted by Congress. I am hopeful that we can spend the next few hours working together to identify areas of bipartisan agreement on the problems facing American workers and on the policy solutions that have a path toward becoming law. I'm encouraged that I've been invited here as a guest of the Republican majority. This is a positive change. Thank you again to Chair Cassidy for your open mind. I have enjoyed and valued our recent conversations. For as long as I have been a Teamster, neither party has spearheaded an effort to reach bipartisan agreement on labor reform. The Democrats have played political football with massive labor reform bills. Republicans have largely reintroduced business-friendly bills that make it harder to form a union. I don't like to waste time. I was elected to get things done for rank-and-file Teamsters, to further solutions and not dwell on problems or the past. Everyone in this room was similarly elected to produce for your own constituents. When I took office, I directed the Teamster Union's legislative department to confront their own partisan bias. As a result, our union has found new allies on both sides of the aisle. Senator Hawley has been essential in that effort. Senator Hawley's pro-worker framework includes pragmatic solutions to problems workers face every day when they form their union. We appreciate that the Hawley framework is being introduced as a series of individual bipartisan bills and not as one massive reform package. Thank you. There is a realignment around labor taking place within the Republican Party. The Teamsters Union wants to encourage that movement by offering multiple paths to support our members and not a single legislative litmus test. After workers vote to form their union, many employers delay the negotiation of initial collective bargaining agreement. Nearly half of new unions fail to secure a contract within a year of winning an election. After 2 years, a third are without a contract. Senator Hawley, Senator Marino, Senator Booker, and Senator Peters have introduced a bipartisan bill called the Faster Labor Contracts Act. This bill ensures that a first contract can be reached in months, not years. The Faster Labor Contracts Act doesn't favor any one party over the other. It simply ensures that bargaining results in a contract rather than the stalemate. This is the first time in recent memory that we have labor reform legislation that is both bipartisan and bicameral. This shows a recognition that labor law must work better for the American worker and that both parties have a role to play in this effort. Corewell is Michigan's largest state health system. At Corewell, 10,000 nurses organized with the Teamsters Union last year, 10,000. It took the hospital system 7 months to come to the table and start to negotiate. During the few bargaining sessions that have attended since, Corewell management has slow-walked every issue and avoided speaking about the concerns that drove the nurses to become Teamsters in the first place. Breakthrough Beverage is another example, one of the largest beverage wholesalers in North America. The company has reported over $8.5 billion in annual sales. In September 2024, Breakthrough drivers in Florida joined the Teamsters Union. 13 months later, they are still without their first contract. And at Amazon, JFK 8 warehouse on Staten Island, workers voted to unionize in April in 2022. More than 3 years later, still no contract. The reason Faster Labor Contracts Act could be so successful is because how simple it is. This is a rare example where legislatures of all stripes put forward easily digestible reforms that can immediately improve the lives of their constituents. For organized labor, the bill would resolve one of the biggest problems we encounter on the ground. Last week, the Teamsters hosted a special event celebrating the legacy of Rerum Novarum and shared work of the Catholic Church and organized labor. Rerum Novarum was written in the wake of an industrial revolution. It reminds us that humans are not instruments meant to be ground down and discarded. The economy must exist to serve humanity, not the reverse. In the Teamsters, our members are empowered to build families, receiving wages and benefits needed to support their children and partners. As a Teamster, you have a stake in sustaining a strong community. You know what it means to buy a home, to invest in the future, to pay taxes and dues, and to live with the dignity of knowing you can provide for your loved ones. The dream escapes so many Americans today. At its core, the Faster Labor Contracts Act is about restoring that reality. Thank you for your kind attention today. I look forward to answering your questions.
Thank you. Next, we turn to Ms. Gressler. Rachel Gressler is a Senior Research Fellow in Workforce and Public Finance at the Heritage Foundation. Before joining Heritage, she was a senior economist on the staff of the Joint Economic Committee of the Congress. She completed her graduate studies in economics and public policy at Georgetown and her undergraduate studies at the University of Mary Washington, where she currently serves on the Board of Visitors. Please.
Chairman Cassidy, Ranking Member Sanders, and members of the committee, thank you for the opportunity to be here today. Since its inception, America has transformed from an agrarian to an industrial to a services-driven economy, with technology continually making us more productive and our work easier. Today's workers are more mobile, our jobs are more diverse, and our workplaces are more agile. The last decade has included massive expansions in things like remote work, flexible schedules, and benefits like paid family leave. And online work platforms like Upwork and Instacart have created new income opportunities and expanded the workforce. But one thing hasn't changed, and that's workers' desire for a voice and their personal rights in the workplace. Yet, most of America's labor laws are 75 years old and were enacted in a male, union, and manufacturing-dominated labor market that does not reflect the realities of today's expanded innovation and merit-driven workforce. When considering current labor issues, I want to acknowledge some potential unintended consequences of government dictates and make the case for a pro-worker modernization of labor laws. First, it is understandable that after voting in a union, workers want quick action. But the Faster Labor Contract Act's arbitrary and unrealistic deadlines and its ceding of authority over private contracts to unelected government bureaucrats could hurt workers. For example, the act could strip workers of the right to vote on contracts, reduce unions' clout in negotiations, limit the effectiveness of workers' right to strike, and potentially even lead to slower contracts. Moreover, the act could face legal challenges because mutual assent is an essential element of a legally enforceable contract. It also does not go unnoticed that this hearing is taking place amidst a government shutdown because two parties could not come to an agreement within a designated time period. That is unfortunate, but it does not mean that an unelected bureaucrat should be given power over the people's elected representatives. Next, the Warehouse Worker Protection Act seeks to address legitimate safety and wellness concerns in certain large warehouses. It does this by regulating some and forbidding other quotas, resurrecting a failed and excessively burdensome ergonomics standard, and implementing a new office within the Department of Labor. Despite its intent to help workers, this top-down dictate could end up hurting them, for example, by expediting the pace of automation and eliminating jobs. After all, robots come with built-in production quotas. They don't require breaks or ergonomic accommodations, and they can't sue their employer. The Warehouse Act may also cause discrimination in hiring against individuals who might require more accommodations. And most dangerous is the slippery slope that this would take towards central planning, with the government dictating private companies' operations and creating a less efficient economy. Yes, warehouse workers' 4.3% injury rate is higher than the average, but it's lower than many others, including 5.2% in public administration, 6% in hospitals, 8.5% in nursing homes, and 10.9% in performing arts. Passing similar laws for these and other industries would put the U.S. on the road to serfdom. Instead, workers need laws that put them in control, starting with the National Right to Work Act that would let all workers choose whether or not to join a union. Next is the Employee Rights Act, a comprehensive pro-worker modernization package that preserves people's rights to work independently. It protects pathways to entrepreneurship that are free from corporate control. It ensures secret ballot elections and limits voting to U.S. citizens and legally authorized workers. It gives workers the freedom of association. It prevents DEI discrimination in union contracts, and it requires unions to get permission from their workers before using their dues for politics. In addition, a package of bills recently introduced in this HELP committee would unlock workplace benefits for independent workers, and the Worker Enfranchisement Act would create more democratic workplaces. America's workforce is dynamic and resilient, and it has the potential to become even more so. Workers' core priorities: job security, upward mobility, personal freedom. They have remained steadfast even as technology, demographics, and workplace structures continue to evolve. When addressing concerns, good intentions don't guarantee good outcomes, and history shows that when the government replaces collaboration with compulsion, both workers and employers lose. A better way forward is to modernize labor laws to preserve the freedom, dignity, and opportunity that make an American work exceptional. Thank you.
Thank you. Next is Mr. Marvin Kaplan, a principal in the law firm Jackson Lewis. Immediately prior to joining Jackson Lewis, Mr. Kaplan was chairman of the National Labor Relations Board. Before his eight more than years of, the person who wrote my script is a little awkward today. You know, I have to go back to that. He served as chief counsel of the Occupational Safety and Health Review Commission, the Workforce Policy Council to the U.S. House Committee on Education and the Workforce, Oversight Council to the U.S. House Committee on Oversight and Government Reform, Special Assistant in the U.S. Department of Labor's Office of Labor Management Standards, and as an associate with the law firm McDowell, Rice, Smith, and Buchanan. Mr. Kaplan received his J.D. from Washington University in St. Louis, his B.S. from Cornell. Please, sir.
Thank you, Chairman Cassidy, Ranking Member Sanders, and committee members. Thank you for this invitation to participate in the hearing today. It is an honor to appear before you again. As was mentioned, I just finished my term on the board, and after issuing close to more than 900 decisions, I have a unique perspective, I think, on how the board functions and how it works and does not work. I'm here today to discuss the first contract collective bargaining under the National Labor Relations Act. The NLRB is not a party to collective bargaining and does not dictate the terms of collective bargaining agreements. Instead, the NLRB establishes standards and imposes remedies to ensure employees, through their chosen representative, and employers bargain in good faith. This framework leaves the terms of the collective bargaining agreement in the hands of those with the best knowledge of the employee's needs, and the economic conditions of the employer, while respecting the Section 7 rights of employees. Like most things that matter, these negotiations take time. Additionally, the time it takes to reach an agreement depends on a number of factors, including the number and complexity of the issues, the parties' bargaining experience, and the current state of the business and the economy. As such, the success or failure of collective bargaining should not be judged by the time it takes to reach an agreement. There are two methods through which a labor organization becomes the exclusive representative of a unit of employees under the NLRA: recognition and certification. Both recognition and certification bar any challenge of the labor organization's representation for up to 12 months. While the bar fundamentally conflicts with the Section 7 right of employees to choose whether or not to be represented by a labor organization, the installation periods serve the overarching goal of the NLRA, labor stability. The employer and the certified or recognized labor organization must bargain in good faith regarding the terms and conditions of employment. This obligation persists until the employer has objective evidence that the labor organization has lost majority support and either a collective bargaining agreement is not in effect or has expired. The employer violates Section 8A.5 if it fails to bargain in good faith, and the labor organization violates Section 8B.3 if it fails to bargain in good faith. To satisfy the good faith requirement, the employer and the labor organization must negotiate with a bona fide intent to reach an agreement. However, the employer and the labor organization are free to engage in hard bargaining and exert economic pressure, including strikes and lockouts. Neither the NLRA nor the NLRB set the frequency or duration of negotiations or the terms of the agreement. Certain actions have been considered per se refusals to bargain. However, more often, the NLRB considers the totality of the conduct to determine whether the employer or labor organization is acted in bad faith. In almost all of the cases where the NLRB finds bad faith bargaining, the NLRB orders the offending party to cease and desist from refusing to bargain and bargain upon request. The NLRB has also issued bargaining orders, mandating a period in which the bargaining must occur and extending the certification or recognition bar. In more serious cases, the NLRB may issue a bargaining order, a broad bargaining order, that extends the bargaining order to cover all unit employees covered by that labor organization. More tailored remedies, including reimbursement of bargaining expenses, have been ordered if a party engages in surface bargaining. In the event the offending party fails to comply with orders, the NLRB can petition the U.S. Court of Appeals for a judicial order enforcing its decision. A party that does not comply with the court's enforcement order may be held in civil or criminal contempt. In some cases, even when parties bargain in good faith, they may still be unable to reach an agreement. The NLRB defines this moment as impasse. Like bad faith bargaining, impasse is a question of facts evaluated under the totality of circumstances. Impasse merely suspends the duty to bargain until there is a change in circumstances. Numerous studies have examined the time between recognition or certification and the signing of the first contract. A 2009 study found that 48% reached a first contract within 1 year, 30% had no contract after 3 years. A 2021 analysis found the average time to contract to be 409 days. While these numbers may appear concerning, they do not indicate that either employers or labor organizations are bargaining in bad faith. On the contrary, they are an acknowledgement that good faith bargaining takes time, and in approximately 70% of cases, an agreement is reached within 3 years. There are egregious examples of bad faith bargaining. I know because I was on the board when they came before us. But the NLRB has effectively dealt with these situations. During my time on the board, I regularly reminded myself not to allow bad facts to make bad law. I encourage everyone to consider this before endorsing a significant shift in bargaining procedures under the NLRA. I will conclude by saying the system works, in my opinion. I look forward to answering any questions from the committee, from the members of the committee, and I would just say, tomorrow you will be voting on new members for the NLRB. The best way through which these issues can be dealt with is by having a quorum at the board again.
I recognize now Senator Sanders to introduce the Democratic witnesses.
Thank you, Mr. Chair. I'm pleased to introduce Jennifer Abruzzo, who is the Senior Advisor to the President of the Communication Workers of America, the CWA. Ms. Abruzzo spent nearly 30 years at the NLRB and most recently served as the NLRB General Counsel, and in my view, served as the most pro-worker General Counsel in the modern history of the NLRB. So, Ms. Abruzzo, I thank you very much for your years of service and your pro-worker advocacy. Thanks for being with us today.
Thank you, Chairman Cassidy and Ranking Member Sanders and committee members. I did serve the public for almost 30 years at the National Labor Relations Board, ultimately serving as its general counsel before I was fired earlier this year. Before I continue, I would like to thank all the currently furloughed government employees. Please stay strong. We understand you and your families are suffering along with us, and we very much appreciate your extraordinary commitment to serving the public. I appreciate the opportunity to speak today about the vital importance of protecting workers' rights in this country. That includes addressing NLRB operations as well as shortcomings in the NLRA itself. We all know that the power dynamics at workplaces are skewed, such that corporate power dominates to this day. In enacting the NLRA, Congress sought to address that power imbalance by trying to level the playing field and give workers the rights to unionize, collectively bargain, and act together to seek better wages and working conditions without fear of retaliation. Congress back then rightly recognized that to have fairness at workplaces meant fostering strength in numbers. Over the course of my tenure, I unfortunately have seen employers engage in many tactics to squelch workers' voices and choices. And despite the hard work of dedicated and talented career staff, the NLRB, as a chronically underfunded and understaffed agency, remains unable to truly effectuate U.S. policy of encouraging collective bargaining by protecting workers' full freedom of association. So the problems are that neither the NLRA nor the NLRB are fully empowering workers and protecting them in this country. Here are some solutions. If you are to put working families first, as I believe you must, then you need to make serious investments in the NLRB. For years, it hasn't been sufficiently funded, and what this means in real terms for working people whose rights have been violated is that their cases are languishing. Unfortunately, corporations can afford to drag out government processes for years, but workers cannot. But providing sufficient funding is not enough, nor is confirming 2 new board members, although I do believe it's crucially important to have a quorum. For 8 months, this administration has deprived the board from issuing decisions. And who is benefiting from that dysfunction? Not workers, but employers, who feel emboldened to violate the law with impunity and retaliate against their workers because there's no functioning board to hold them accountable for their law-breaking activity. Corporate billionaires and CEOs are trying to get rich off of the backs of employees while trying to silence them. They don't need more money or more tax breaks. Workers and their families do, and they need good, affordable health care. Employers should respect and recognize their workers for the value that they add, and I implore more senators to ensure that corporate interests are not elevated above workers' rights. Next, this Congress needs to fight to maintain the statutory independence of agencies like the NLRB. This president believes he has the absolute power to ignore statutes passed by you, passed by Congress, to fire people at whim, and to give his campaign donors a blank check to trample upon the rights of workers to unionize and act together to improve their situation. And last, but certainly not least, Congress needs to do a major overhaul of the current labor law to address the gaps that sadly just keep widening. The PRO Act would, among other things, broaden coverage, promote organizing and first contract bargaining, enable workers to better exercise their power, and would assess reasonable costs for violations to deter them. I'm all for its passage, which could be a floor from which states could elevate, but I don't even think that's enough. If we are serious about promoting collective worker power and workplace democracy, then we should be expanding our thinking and consider models that have been successfully implemented elsewhere, such as sectoral bargaining. If this Congress fails to protect workers and their families, whose interests you were elected to represent, then I expect that workers will not only elect different legislators next fall, but will return to the self-help activities predating 1935, and that includes wide-scale protests and strikes in order to retake control of our governance, to gain or regain the benefits that were earned through hard work, and to receive the dignity and respect that is so richly deserved. So let's all do our part so that we remain a country of the people, by the people, and for the people. Thank you, and I look forward to your questions.
Thank you very much, Mr. Russo. Steve Cochran is a UAW leader in Chattanooga, Tennessee. He has been working as a skilled trades worker at Volkswagen's Chattanooga, Tennessee plant for 14 years. After he and his co-workers voted overwhelmingly to join the UAW in what was an historic victory, one of the first major organizing efforts in the South, Mr. Cochran was elected by his co-workers as co-chair of the Local 42 Bargaining Committee to negotiate the first contract between the UAW and Volkswagen. Mr. Cochran, thanks so much for being with us, and thanks for your great work.
Good morning, and thank you, Chairman Cassidy, ranking members. Excuse me? Yeah, it's red light's on, yes.
Pull
Okay.
it a little bit closer to yourself.
Good morning, and thank you, Chairman Cassidy, ranking member Sanders, and the members of the committee for the opportunity to testify to y'all today. My name is Steve Cochran. I'm a proud automotive worker at the Volkswagen in Chattanooga, Tennessee. About a year and a half ago, my coworkers and I voted 3-1 to join the United Auto Workers. A year later, we still do not have a union contract. We're still waiting for the company to agree to a proposal that simply affords us a fair share. We are living with health care that forces people into bankruptcy. We are living with no protection from inflation. The company has repeatedly violated labor law to delay us our fair share. They have unlawfully cut jobs at the Chattanooga plant. They have unlawfully refused to bargain in good faith. They have presented us with a quote-unquote final offer that maintains subpar health care, doesn't protect our wages from inflation, and makes no commitment to keeping the good jobs in Chattanooga there. And this is a pattern for Volkswagen. Earlier this year, our brothers and sisters at the Volkswagen Distribution Center in New Jersey organized their union. But the company broke the law so extremely in the anti-union behavior that the National Labor Relations Board had to step in. Last week, the NLRB found merit in the union's allegations and said it was seeking an order requiring the company to recognize their union and to negotiate with the workers. So we know this company and many other companies just break the law. We know it's possible to enforce the law and force companies to negotiate with their workforce. Why are we not getting the support in Tennessee? Why does Volkswagen get to break the law and screw Tennessee auto workers out of their fair contract? We've had to file federal labor charges against Volkswagen over and over again during these negotiations. Volkswagen unlawfully cut jobs during these negotiations without bargaining with the workers. That's against the law. Volkswagen has repeatedly gone back on their proposals and bargained in bad faith. That's against the law. Volkswagen has intimidated workers for exercising their right to vote yes on a strike authorization. That's against the law. The best we can do is pass new laws like the PRO Act, but at least we can do is enforce the laws that we have on the books now. Your average worker has to fight like hell to win their union against constant illegal activity from their employers. If they overcome that to win their union, they have to fight like hell to win their union contract and actually improve their lives. This process can take years. And every year, this is a slap in the face of the workers who make these companies profitable. I've worked at Volkswagen for 14 years. We show up every day to do our jobs. We do what our members of Congress ask us to do. We make high-quality vehicles in the United States. We follow the rules, and we want our union fair and square with a National Labor Relations Board vote. I'm providing for my family, and I'm contributing to my community. We're doing our jobs. The question is, why isn't the federal government doing its job? All we are asking for in Chattanooga is a union contract. We're asking for a fair wage, health care that does not put us into bankruptcy, and basic rights that thousands of auto workers already enjoy at Ford, General Motors, Stellantis, and automakers across the world. Volkswagen made $20 billion in profit last year. And yet, when it comes down to doing right by American workers in Tennessee, they break the law with impunity. And the federal government is painfully slow to act. Members of Congress are silent, and working class people in Tennessee pay the price. There's no question that workers in this country need new laws like the PRO Act. And if the Faster Labor Contract Act were already a law, us at Volkswagen would have a contract. But even if we can't pass those bills, we can still make the union busting stop. You can fully fund the National Labor Relations Board so that it is able to do its job. You can stand with the U.S. workers who are y'all constituents when management tries to stop us from voting for a union and exercising our right to negotiate. You can tell corporations with one voice loud and clear that those rights are already protected by the United States of America. So we ask the committee, it's great that we're here to talk about changing law, but understand that Volkswagen and many Fortune 500 companies like it are breaking law every day. I'm doing my best to provide for my family. I'm doing the best to provide a world-class automobile. I'm doing my best to do by the book. Form a union and win a better life. When will Volkswagen do their job and follow the law? When will the federal government do your job and enforce the laws? When will working-class people get their fair shake when they stand up for themselves? I thank you for hearing me.
Thank you. I'll begin with questions. Mr. Kaplan, you just made a case that the system works. Ms. Abruzzo and Mr. Cochran refute that. How would you respond to them?
I think, excuse me, I think they highlight the time it takes to get a decision issued by the board, and at times it has taken too long. I think there's an understanding that it could work faster. I would say when we were in the majority under the previous administration, our backlog was at its lowest.
When you say we, you mean?
I'm sorry, yes. 9 years on the board, you end up talking to yourself as if you're still a member of it. The board itself, when the Republicans were in the majority, we got the backlog down to the lowest levels, probably in recent memory.
So Ms. Abruzzo, who I'm sure will differ, but her point that the under-resourced, the implication is with current resources cannot manage. Your point was that in previous times with roughly equal resources, you were actually able to get the backlog down.
I think the question becomes, so there's two sides of the board. There's the board side and there's the GC side. The GC side, the argument is there's not enough staff there to work on those cases. I would argue on the board side there is, and that the board has worked effectively when it has made those efforts to be able to address.
But then going back to Mr. Cochran would make the point that, tell us how you would view his statement in terms of, it's taken too long to get a deal sort of thing.
Well, I don't know the specifics of the Volkswagen deal but there's been other statements here talking about JFK 8 and the issues there. And let me just say, if you've read my dissent in JFK 8, there were a lot more issues going on there than merely what collective bargaining or what was appropriate or what terms were at issue. These were issues with the representational election itself. So delays, I would argue, are not necessarily just at the bargaining table. They can relate to different things. And the time it takes for the board to analyze a charge, determine whether it's meritorious, and then create the record through which a decision can be made does take time. But it's that time that provides the information that is necessary to make a thoughtful decision at the board level. At times, the board has not worked as effectively as I would argue it could with regard to adjudicating those cases and determining merit or determining what remedies were appropriate. But I would say the board, as it exists today, is able to make those determinations in a timely manner. Whether the GC side works fast enough with regards to making its determinations on merit and whether a charge be filed at all is a different issue entirely, and I think it depends on the general counsel.
Mr. Cochran, I'm told that Volkswagen made an offer to the union, but that the union did not present it for a vote. Any circumstances around that we should know?
Well, at their own admission, Volkswagen said that offer is full of clerical errors, and they're not letting the people see the entirety of it. So that's something, until all that stuff is settled out, how do we bring it back to our workers? When the company itself says it's full of clerical errors and it must be approved by their board before they can make sure it's right.
Now, Ms. Gressler, sometimes 30% of these go beyond 3 years. Is that equally divided as responsibility between labor and unions, or is that more one or the other, or tell us?
Yeah, it's both. Both sides have a lot at stake here. These are legally binding contracts for multiple years, and especially when establishing the first contract, that can take a lot of time to figure out what are the issues. Is
So
what's
any
being
sense of
proposed-
relative percent between the unions versus the employer as to who's responsible for it not being completed within 3 years?
I don't have an average.
Mr. O'Brien, what would be a reason for a union to not agree to, my same question, if you will, it can go beyond 3 years. And so some of these bills would seek to put a shot clock on it, but apparently sometimes it's labor which does not agree to a contract within 3 years. Perspective on that? I don't agree with that statement. Microphone, please.
You weren't there to help me out. I don't agree with that statement because when we're organizing, I was an organizer. I've been in the union 35 years. I've held every position. When I was organizing, when employees seek to unionize their workplace, they come to you and they identify all the issues. And you formulate, at that point in time, you start formulating potential solutions in the event you get to an election. So you are well prepared on the issues, on what is causing a workplace to form a union. For something to take three,
I'm out of time. I may come back to that at the end.
okay.
Okay, I'm trying to keep us on track. Next, Senator Sanders.
Thanks, Mr. Chairman. I got a lot of questions in a short period of time, so I need your help here. Let me begin with yes, no, maybe, on a half a dozen questions. Just yes or no, if you could, starting with Mr. O'Brien. Mr. O'Brien, do you believe it was constitutional for President Trump to terminate the union contracts of 500,000 federal workers and eliminate collective bargaining for 500,000, for 1 million federal workers?
Sir, I'm here to talk about the.
Okay, just pass on it. If you don't want to comment, that's okay.
I'm here to talk about the Fast
Okay.
Labor Contracts Act.
Ms. Gressler?
It's legal in some cases, and certainly some of those will be litigated in which instances.
Mr. Kaplan, very briefly.
The benefit is the court will determine whether it's lawful or not.
Ms.
No.
Abruzzo? Mr. Cochran?
No.
Mr. Ryan, do you support the PRO Act would make it easier for workers to form unions and hold corporations accountable for illegal union busting?
I support legislation that is going to actually help organize, but we have,
I'm sorry, I just got a lot of questions.
we got the AFCA didn't.
Yes, no,
I
maybe?
support legislation that's going to help workers unionize and get to a first.
Ms. Gressler?
No.
Mr. Kaplan?
I think it starts the narrative, but
I apologize, yes, no?
no.
Yes.
Mr. Abruzzo? Mr. Cochran?
Yes.
Mr. Ryan, do you support gradually raising the federal minimum wage from the starvation wage of $7.25 to at least $17 an hour over a period?
Yes.
Ms. Gressler?
Minimum wages should be a state issue.
Mr. Kaplan?
I agree minimum wage should be a state or locality.
Mr. Rizzo?
Yes.
Yes.
Cochran? Mr. Bryan, do you support doing what every other major country on earth does, guaranteeing all workers at least 12 weeks of paid family and medical leave?
I negotiate for living wages and the different pay
Okay,
leaves.
thank you. Ms. Gressler?
I do not support one-size-fits-all paid family leave policies.
Kaplan?
I have to admit, I think that there are opportunities there, but I'm not sure what the right answer is.
Rizzo?
Yes.
Mr. Cochran?
Yes.
Mr. Bryan, do you agree with Amazon, Jeff Bezos of Amazon and Elon Musk of SpaceX, that the NLRB is unconstitutional?
I do not agree.
Ms. Gressler?
Unsure.
Kaplan?
It's a question for the courts.
No.
Rizzo?
No.
Okay. Let me go to Mr. Cochran. Mr. Cochran, thank you very much. Last year alone, Volkswagen made nearly $17 billion in profits and could afford to pay its CEO, Mr. Bloom, $11 million in total compensation. Do you believe Volkswagen can afford to give your members a decent contract with fair wages and benefits?
Thank you for the question. And of course, I mean, anybody understands they can. Actually, the less than 4 cents for every dollar they make goes to the worker in Chattanooga for the cars we sell. Less than 4 cents. So yes, they can afford to pay us a better wage.
Mr. Cochran, as of today, as I understand it, it's been 526 days since you and your coworkers voted to join the UAW. Why, in your view, is it taking so long to get a first contract?
There are several factors in why it's taking so long. A lot of them are bargaining in bad faith. where you try to work on something with them and they come back with something different than what it was, and you agree to that, and they change it again the next time around. So you're trying to figure all that out. So it's the constant taking 6 months. They started bargaining because they had to get their stuff together. It's the bargaining. We meet with them, and they don't meet back with us. We have language we passed to them in October of 2024. They have yet to answer. They haven't even answered it.
Okay, Ms. Russo, we have heard some different opinions this morning, including from your former NLRB colleague, Mr. Kaplan, who says the system works. In your view, based on your decades of experience at the NLRB, is the system working for the working class of this country?
No, the system is rewarding lawbreakers in this country. The current NLRA has very weak penalties. There's no self-enforcing board orders, so that adds much delay and allows employers to abuse the process.
Why are multi-billionaires like Bezos and Musk challenging the constitutionality of the NLRB?
Because they don't want to be held accountable for their lawbreaking activity.
Thank you very much.
Senator Paul.
Quite a few business entities have weighed in on the faster labor contracts bill. I have a list of 29 associations, including packaging, chemical distribution, hotel and lodging, pipeline contractors, truckers, builders, contractors, a whole host of associations. And I'd like to ask unanimous consent that these organizations that are opposed to the Faster Labor Contracts Act be entered into the record.
Without objection.
I also have a list of 45 different business association groups opposed to the Warehouse Workers Act, and I would ask unanimous consent that those be entered into the record.
Without objection.
Ms. Gressler, can you give us an idea of how right-to-work states compare with non-right-to-work states, business formation, economic growth, unemployment, things like that?
Yeah, so over the past 50 years or so, we've seen about 2 times the employment growth and 3 times the population growth in these right-to-work states. And that's because they attract more businesses because they have the certainty of knowing that they will be able to set up their shop and not have a union come in and take control over their operations.
How do wages compare? Do you think the right-to-work states are just, are exploiting their labor and paying their workers less? How do workers' wages compare right-to-work, non-right-to-work states?
Yeah, thank you for asking that because that's often misunderstood. But when you actually do an apples-to-apples comparison of wages in right-to-work and non-right-to-work states, you see that when you account for the differences in cost of living, that workers in right-to-work states do just as well, if not better, as those in non-right-to-work states.
Yeah, I'm actually impressed as I go around Kentucky to very large international businesses that aren't unionized, how good their workers are doing and how happy their workers are with their job, as well as health care and the whole gamut of things. When we look at the Faster Labor Contracts Act, Ms. Gressler, you had mentioned that it impairs sort of some of the ability on both sides, really. Both labor and business could feel like their full ability to exact their leverage might be limited. Labor might have, over a longer period of time, the ability to strike. The owners might have the ability to let go workers trying to figure this out, the pressure both ways. So it takes some of that give and take away, and it will be replaced, instead of by labor and business, it'll be replaced by then some bureaucrat who's not involved in this.
Yeah, and I think that's really important that it affects both sides of the issue here. And when you have a first contract, especially if you have a company that has never been involved in negotiations or a union, that it's the first time that they're representing workers, they need to understand all of the issues at play, and they need to play those out and say, will this make my company uncompetitive? Might I have to shut down or lose jobs? And for the workers to consider all the different things that they might bargain over, what is most important to them, and what are the long-run implications? Because that first contract sets the stage for decades more of future contracts. And when you look at some of these contracts that are out there, I looked at Ford's contract with the UAW in December of 2023. It's hundreds of pages, thousands if you include memorandums of agreement, and there are 313 items that are listed on the table of contents that they bargained over. So these are too many things for both workers and for employers to be able to consider within a time of 120 days.
Some have argued, such as Hayek, the road to serfdom came up earlier, but have argued that the right to contract really is a basic fundamental right upon which really the economy is based, the right to have certainty and to have honesty and have the courts uphold without an arbitrary nature, but to look at contracts from a dispassionate point of view. So getting involved in the middle of contracts, I think, shouldn't be done lightly, and considering the ramifications of what it does to the economy at large. The National Right to Work law basically just removes some aspects of federal law, doesn't create new law. Then the way the National Labor Relations Act was written says that you can't discriminate against workers. And then they had to put an exemption in there, except for you can discriminate against non-union workers, basically. And so that exemption is what is removed by National Right to Work. What do you think would happen if we had national right to work? What would the general economic sort of scenario be, Ms. Gressler?
I think that it would improve the economy. We'd see what's happened in the states that are right to work, but more importantly, it just preserves that fundamental right of every worker to be able to choose whether or not they are forced to pay a private entity as a condition of their employment, and that's just a fundamental protection that they should have.
Thank you.
Senator Hessen.
Well, thank you, Chair Cassidy and Ranking Member Sanders, for having this hearing, and I thank all the witnesses for being here today. Before I get to my questions, though, I want to take a moment to address the fact that the federal government remains shut down as we are having this hearing. And while today this committee discusses a really important topic, Congress should be working to find a bipartisan path to do two things: reopen the government and take action to prevent health insurance costs from skyrocketing for everybody, and to prevent millions of Americans from losing their health insurance. That is what is at stake right now. So while I look forward to hearing from our witnesses, I'm going to continue to urge my colleagues to come together on a bipartisan basis and reach an agreement to get this done. Now, to Mr. O'Brien, workers are sometimes unaware of their rights and protections under the their protections under the National Labor Relations Act, which I will also just note was deemed constitutional back in like 1937. So this notion that we need to revisit the constitutionality of it seems to me to be misplaced. Mr. O'Brien, we can help overcome that knowledge gap by ensuring that a notice of protected rights is posted in the workplace. You have talked about the need to get some laws on the books a step at a time that help workers. So I'm working with Senator Hawley on introducing legislation that would help achieve this. Can you speak to how advancing common sense proposals like this would help level the playing field for workers?
Yeah, I think it's important that when you go into workplace, whether you're union or non-union, you know your rights. You know your federal rights as an employee. And if you go into any workplace now, whether it's union or non-union, you see OSHA standards posted. You see fair wage law notices posted. You see a lot of postings, but you don't see certain postings on people's right to organize in the workplace. And I think if we're truly going to be consistent about postings, we should include everybody's rights in the workplace and what those rights are. Transparency is a key. And I know this new generation of workers coming into any industry, they are extremely want transparency in the workplace. They want to know their rights, whether it's union or non-union. So I applaud you and Senator Hawley for taking that initiative.
Thank you very much. Ms. Abruzzo, some large corporations use stalling tactics to avoid bargaining in good faith with their employees. What changes to labor law and labor law enforcement do you recommend to address this issue?
Thanks for the question. Let me just give you an example of Amazon, a warehouse in Staten Island, where the workers voted for the union, Teamsters Union actually, back in April of 2022, and Amazon is still not at the bargaining table, October of 2025. And so it is a real problem, and I agree that I think we need to speed up first contract bargaining, but what I will say is it's not enough, because unless you can make more robust organizing rights and protections, you don't get to the bargaining table.
Right.
So it's really important to address that.
So I'm going to follow up with you on some specifics because I think we would all be interested in hearing what some of those specifics might be to get us to this point where the stalling tactics are curtailed, right? And we could enforce the law. Mr. Cochran, just because I've just got a minute, I wanted to move to you. I want to follow up on the question I just asked to Ms. Abruzzo, because you've experienced these stalling tactics firsthand, right, with VW. Given your on-the-ground perspective, what impact do these stalling tactics have on workers who are trying to negotiate?
So the biggest impact we see is it's the fatigue factor. It's where they kind of makes them where they want to give up. They want to stop fighting because they feel like they're winning. There's no win. They can't win it. But with the NLRB standard, Volkswagen also knows too that there's no real penalty for them. They can just push it and push it and push it and push it. And at the end of the day, if they're found guilty of all of it, it's just a notice hung up in the plant saying we won't do it again, and we start the process over again.
yeah.
So the workers feel like there is absolutely no way to win.
Yeah.
That's the big thing. Lucky for us, we have some very strong workers in our plant, and they're not giving up.
Right. Thank you very much. Thanks, Mr. Chair.
Senator Marshall.
All right, thank you, Mr. Chairman. My first question for Mr. O'Brien. I ran a small business and certainly understood how important certainty was to me running that business. But I hadn't spent as much time thinking about the union town I grew up in, where my family members worked for unions and my friends' parents worked for unions as well. How important is, what does the union and the contract do for the certainty of that working family?
Yeah, I'm sorry about today.
Your first rodeo.
Look, a union contract, I'm a fourth-generation Teamster, so I've seen the value of growing up under a union contract. It provides continuity, security, and benefits to families, which takes a lot of the pressure of raising a family, buying a home, planning for the future. It eliminates a lot of that as well. There's this fallacy that a contract or an organized workforce, the intention is to put that small employer or that business out of business. That is not the intention. I negotiate contracts with the largest corporations down to small mom and pops. And the reality of it is, if people want to get to an agreement, a reasonable agreement that both works for the business and their employees, and if employers truly value their employees, they'll respect the employees' wishes to join a union. Now, conversely, if employers do not want a unionized workforce, it's simple. Treat your employees with dignity and respect, pay them the wages and benefits that they deserve, and you'll never see this face.
Thanks so much, Sean. I certainly do, though. I understand. I'm the banker there. I'm ready to make a loan on that young family's first home. And if they're 2 weeks out from that union contract being over with, it's a lot different situation than if they're in year one of that contract, and that's a good loan to make. I think that's some of the certainty I was thinking about as well. Let's talk about joint employer standard. This is something that's real important to us. And I'll stick with Mr. O'Brien on this. We've seen companies abuse the joint employer standards. We've seen it abused. On the other hand, I'm a big supporter of franchises and think that they do a great job, and it's a great opportunity. They've given so many people their American dream of owning their own business, and I think it's great for women, for veterans, for minorities, great opportunities as well. Where's the opportunity to help take care of some of labor's concerns as well as the franchisors' concerns when it comes to joint employers? Is there any opportunity for common ground here?
Well, I think we've seen the joint employer argument go both ways depending on what administration it is. And I know you have a bill pending regarding franchisees, and I'll be honest with you, I haven't taken a look at it. The one thing I'm encouraged about what you're doing is that you are looking for a road to consensus on what actual joint employer means, and defining what that is. Often, 2 times, this joint employer rule has been utilized as basically a regulatory ping pong, where there's really no concrete definition of what joint employer is. We have our own arguments in our own arenas when you're talking about Amazon and big corporations like that, but hopefully with some of this legislation you're putting forth and the conversations, I think what's more important than anything is having conversations and having disagreement, but the disagreement and dialogue leads to a solution that everybody can understand. You may not agree with it, but if there is a concrete definition of what it is, let's just follow what it is and enforce it accordingly.
Give us all some certainty. Mr. Kaplan, I wanted to go to you next. What would be a reasonable amount of time, in your experience, for a newly unionized workers to reach a first collective bargaining agreement? Maybe it's a time frame or a range of time. What would be reasonable in your experience?
I think the unfortunate truth is that it doesn't lend itself to that sort of a clear-cut rule. And I think that that's inherent in where the board sort of sat with the certification bar. When the certification bar was put in, when the recognition bar was put in, people thought maybe 1 year was sufficient. I think that in the current environment where the issues that are being addressed by these collective bargaining units have changed significantly, just recently, there's been suggestions of political issues coming up in collective bargaining, et cetera. In that sort of a backdrop where the issues have become far more complicated, you're in a much different situation than you were when those bars were put in place. So I guess the question and I guess that what's fall back on the question is are you bargaining in good faith? Not is there a prescribed amount of time that these things could be met for everyone, because not every shoe will fit every single individual. And I don't think it's always clear that 30% means that it was a breakdown.
Thank you, Senator Hickenlooper.
Thank you, Mr. Chair. Again, I echo my appreciation, as others have said before, for you taking your time to help us with this. It says it's on. Do I get closer? I'll sidle up to the mic. For the first question, I'd like to direct you to the chart behind me. This chart shows a clear correlation between union membership and, in this form, income disparity. We can see that when union membership is higher, income disparity is lower. The lower middle classes see a higher share of income, and this is correlates over a number of decades. So, Ms. Abruzzo, I'll start with you. Do you agree that a strong middle class is essential to the economic health of our nation?
Absolutely, and unions are there to ensure that the middle class gets their fair share of the profits that they help their operations make. And actually, collective bargaining helps with the income disparity and addresses racial and gender pay gaps.
Thank you. And Ms. Gressler, do you agree that unions are a key part of growing the middle class? Do you agree that a strong middle class is crucial for our country?
I do think a strong middle class is crucial for the country, and I think that it's the workers themselves that need to have the control over what is important to them, and that it's not necessarily a union. A union can be helpful to some workers, and they should have that right to be in it, but others should have the right to not also.
Certainly, I understand those rights, but I think it's startling to look at the decline in union membership as the size of the middle class shrinks. Let me go back and just talk about the credibility of workforce data. And I think it's paramount to making sure that we craft targeted policy, especially when we're going to see these rapid changes around AI. Recent events, the firing of Bureau of Labor Statistics Commissioner McIntyre, other staffing shortages within the department have raised serious concerns about disruptions to our national understanding, let's say, our understanding of the labor market. Mr. Abruzzo, I know your experience is not directly with the BLS, but can you talk about why high-quality, transparent data and analysis is important for all of us to understand how the workforce is changing?
Thank you for that, and I couldn't agree more. I mean, numbers shouldn't lie, and the government should be transparent to better inform everybody. But you mentioned something that I would like to address, and that is AI. And I go back to the issues regarding large corporations, and actually not so large corporations, trying to avoid liability by throwing money at problems, or otherwise avoiding liability by creating models to try to distance themselves from workers despite the fact that they control terms and conditions of employment. And we had a witness that just said a little earlier that the use of AI is important because robots can't sue. And so, it's very important for us to remember that these models are in place not to empower workers, but actually to ensure that corporations retain their powers and put the thumbs on the scale.
I appreciate that. Mr. O'Brien, I was going to ask you just because I have a cousin, the late George Hickenlooper, who was a film director, and I was his rabbit's foot. He would give me cameos in many of his movies, so I ended up becoming a member of the Screen Actors Guild. And I was amazed to see firsthand the connection between the Screen Actors Guild and the Teamsters. And I just thought, in the complexity of labor markets today, that ability for those two unions, I mean, is that a hard, because they support each other intimately, at least in Colorado, is that a hard thing to navigate?
No, not at all. Not at all. I mean, it's common goals. We want to negotiate the best contracts for our members, get them the best working conditions, and that's the principle, whether you're in SAG, whether you're in the Writers Guild, or whether you're in the Teamsters Union in the motion picture industry. But I will say this, there's two things that are threatening the motion picture industry right now: AI, and also these American companies, these film companies going overseas to shoot movies where it's cheaper. We could potentially destroy an American icon in movie production, so we have to be focused on that as well.
Appreciate that. Mr. Cochran, I'm going to submit I'm out of time, and I know what happens when you run out of time on this committee. But I am going to submit a question about all the cancellations of energy projects and what that does for a worker, for the workforce members that you represent. But you'll get that written. I won't dare ask you to verbalize it now.
Okay, thank you.
Senator Hawley.
Thank you very much, Mr. Chairman. Thanks for calling this hearing. Thanks again to the witnesses for being here. I want to start with you, Mr. O'Brien, but first let's just do a little bit of context. We are here to diagnose the issue. I think diagnose the problem. That's the title of the hearing. So let's just take a look at what the problem is that's staring us right in the face, which is the rise of these giant corporations like Amazon, for example. The biggest corporations in the history of America, the biggest corporations in the history of the world, the richest corporations in the history of the world, they're making money like we've never seen before, but they don't want to pay their workers. A lot of times, they don't even want to have workers. They don't want to have American workers. Look at Amazon. Here's their net sales and net income. In 2024, Amazon's net sales topped $600 billion, $637 billion to be exact. Their net income doubled from 2023 to 2024. Doubled. Their CEO is getting paid, let me make sure I get this right, in 2024, Amazon's president earned $40.1 million in total compensation. 40.1. The previous year, he'd earned merely 29.2. I mean, that's an unbelievable, that's great work if you can get it. That's an unbelievable raise. Only problem is, according to their own financial disclosures, Amazon's average worker, average employee worldwide is making $37,181. $37,181. So that's a C-suite to employee ratio of 1,078 to 1. And meanwhile, these guys are fighting you, Mr. O'Brien, every step of the way as you try to get some basic representation for their workers, for their drivers. Tell us about what you've been facing from this company.
I'll get it right at one point. Amazon is probably the largest violator of the NLRA right now. And they have grown significantly, to your point. They focus on 150% turnover ratio in their workforce. They focus on distressed communities. And the number one violator of OSHA, they've got the most violations last time we checked. Now, we have a model that's a similar company that employs similar workforce at United Parcel Service, 340,000 Teamsters that are part-time and full-time. Those part-timers earn full-time benefits, health and welfare and pension. They earn they earn wage increases guaranteed every year. They earn a livable wage, and most importantly, they have a path to a full-time career. That on the average, the UPS full-time employee makes about $140,000 per year for doing the same business, and UPS is a very profitable business.
Boy, you talk about $140,000 and change. You talk about that versus 37,000. I'm just thinking back to your reference to rerum novarum, the dignity of the individual. I mean, how are you supposed to raise a family on $37,000? The difference between that and what you've been able to secure at UPS is incredible. Let me just ask you this. Amazon is also one of the biggest offenders when it comes to not negotiating with workers who've decided to unionize. You mentioned Staten Island. I think they're still waiting for a first.
Yeah, Staten Island was organized in 2022 under the ALU. It took a certain amount of time to get certified. Once certified, the intent is to sit down and bargain a contract. We actually represent those workers now. In 3 years, we have not been able to get them to a table. It's been stall tactics, obviously challenging the constitutionality of the NLRA, but also filing charges at the NLRA, so the NLRB, so they are, contradicting themselves every turn of the way just to use union avoidance. And I believe there was a article in the Economic Policy Institute, which was dead on, that stated, Amazon has zero intention of engaging in real good faith collective bargaining with representatives of Staten Island workers. In fact, their business model, which relies on high worker turnover and avoiding responsibility for their employees, is designed to make union organizing nearly impossible.
In that context, tell us why the Faster Labor Contracts Act is so important. Important to put a shot clock on these big corporations so they can't just say, well, you voted to unionize. Good luck to you. We're never, ever going to sit down and talk to you.
Yeah, the Faster Labor Contracts Act has timelines. It has consequences for bad behavior. And I think it's important that if and when this Faster Labor Contracts Act is passed, bad actors like Amazon will be forced to the table, will be forced to negotiate, and will have to agree to a first-time contract without retaliating against the employees. And you will see a continued workforce that has a future under this Faster Labor.
I just want to say this in conclusion, Mr. Chairman. Many folks on our side of the aisle talk about their concern about woke corporations, and I'm worried about woke corporations too. You want to make woke corporations a thing of the past? Make them accountable to the American worker. Empower the American worker. Give them a voice. That's the solution. Thank you, sir.
Senator Kim.
Actually, I just want to build off of what my colleague just talked about here. Mr. Cochran, you laid out all the different challenges that you've been facing here. What would you think would be the impact of actions like the Faster Labor Contracts Act or the PRO Act to what it is that you're trying to get done?
Well, it's obvious that I wouldn't be sitting here today with the testimony I've given a year and a half and not a contract. So it also put timetables. The company would have to meet certain criteria to move forward, or somebody would help step in and make sure it's done correctly.
To be able to add some structure, not trying to dictate the outcome of the contract, but to try to make sure that it's keeping up.
Hold people accountable basically on both sides, so.
Yeah. Ms. Abruzzo, I wanted to just touch base with you. We had heard earlier from Ms. Gressler that her understanding is that workers are doing well, if not better, in right-to-work states. You saw my colleague talk about sort of broader questions about income inequality nationwide, but I'd be interested in just hearing your understanding of just sort of state by state, whether or not you agree that with Ms. Gressler's conclusion.
I don't agree, and it's been reported repeatedly that when you have union representation that can actually negotiate at the table for improved wages and benefits, that represented workers on average in the same industry, same classifications, make at least 13% more than non-unionized workers in the same industry and same classification. So it's hugely important that workers have a voice at the table and have good negotiators at the table that can bargain on their behalf. And I would say for every, there are high road employers out there that do collectively bargain with unions as their workers' representatives, but they're far and few between, and there's no incentive under the current NLRA, actually, to bargain in good faith because you're actually at a competitive disadvantage when compared to many, many employers and corporations that refuse to bargain in good faith and abuse the NLRB's processes.
Yeah, thanks for that detail. I think one thing that stood out to me when I was looking into some of the data here is that it's not just about the union workers, is that some of these states that have the highest union density, it's about lifting the bar for everybody in that state. So for instance, about 70% of states with the highest union density, they've enacted paid sick leave legislation, compared with just about 11.8% of low union density states. Does that resonate? Is that just a coincidence, or do you think there's a correlation, a connection there?
No, absolutely not. It's why it's not a coincidence. It's why I say we need to be thinking more boldly and we need to be thinking about sectoral bargaining and models like that. There are states that actually have promoted and put together wage boards or industry standards boards because they want to have the same wages and standards in a particular sector or industry in order to take wages and compensation off the table so that your companies are no longer competing over wages and compensation. And what they should be competing about is the quality of the products and services that they provide, not the wages and compensation of their workers.
Ms. Abruzzo, I'd like to just stay with you for a second here. Mr. Kaplan raised this question about the backlog at the NLRB and said that when it was under Republican leadership, that backlog went down, that it's not necessarily about needing more resources. But when I look at this, I mean, there are different ways to bring down a backlog, right? You know, you can take some steps to be able to, you know, try to adjudicate and try to work through the cases and put in that effort. But there are also ways in which you can dramatically reduce some of that backlog through dismissing cases or saying that they don't have merit. I guess I wanted to just get a sense from you, from what you saw from your time there, and how different ways have, how Republicans and Democrats have handled trying to address the backlog.
Right, and so what the former chair correctly noted was there is a complete divide between the board side, which is around 100 folks or so, and the general counsel side, which is over 1,000 folks. And the general counsel side, of which I led, investigates and litigates cases. And without proper funding and proper resources and proper staff, you can't do the investigations and litigation that needs to get done. And so it is critical, but again, as I said before, it's not enough. And frankly, the NLRA, there's delays inherent in the process because board orders, even if the chair were to institute a speedy round of getting board decisions done, board orders are not self-enforcing, so employers then can go into court and drag the time out in court before any sort of order actually comes down.
Senator Husted.
Thank you, Mr. Chairman. When I was a kid, I remember my dad and my uncles having conversations about labor management issues because in Ohio at the time, factories were closing, it was a shrinking pie, and people were struggling, including many members of my family. And it occurred to me then, compels me now, that there has to be a way in America for workers and businesses to succeed. And one of the ways that we do that is by growing the pie. And we have an opportunity now in this country as America sees this necessity for our economic and national security to make more things in America. It's essential that we do that. And I think we're at a turning point where we have an opportunity to grow that pie. And but we also understand we have foreign competitors. We also understand we have inflation that we want to fight against because nobody wants to pay more and people want to stay in business. The good news is we have technologies that are emerging that allow us to create more productivity, quality, and efficiency and grow that pie for everyone. But it's also a threat to displace people in their jobs, and that makes a lot of folks nervous. We have to find a way forward where both of those things can work, and particularly as it relates to artificial intelligence. And I'll start with you, Mr. O'Brien, because for Teamsters, technology can make them safer as drivers, but it also can threaten their jobs. And I just want to give you a chance. I'm going to ask some others. How are you thinking about that issue, and what do you want us to know about it?
Well, technology, artificial intelligence is definitely a threat to jobs in this country. And I just want to actually recognize the bipartisan effort on the AI moratorium that you all took to make certain that states had the ability to regulate the implementation of AI, which was important. I think it was a step in the right direction to collaborate and actually get something done on both sides. So I commend everybody for that. AI is probably the biggest threat to any and all industries. And efficiencies are great for the workplace. Efficiencies and productivity do help businesses, and they help the safety of workers. And I don't want to look like we are trying to be an impediment to any type of implementation of technology, especially if it's going to make our jobs easier and safer. I mean, look where we came
Do you think this is something we should
we should be
engage in?
working on together and focused on it because we should find solutions to these problems. If AI is going to compromise jobs, let's find a way to retrain people whose jobs may be compromised. Because look, AI can't swing a hammer, fix a toilet, or wire a house.
In making them more productive, we can pay them more.
Well, that's the theory, because look, there's going to be a lot of white-collar jobs that are going to be affected by this for the first time. There's going to be a layer of management that is going to be taken out, saving these corporations hundreds upon hundreds of millions of dollars. And instead of that going to the CEO, we should pay the existing workforce more and drive those wages up.
Yeah, thank you. Ms. Gensler, I'll give you a chance to.
Yes, AI is another form of automation that has existed for centuries, and in the long run, it is a positive thing that makes us more productive, and workers who are more productive gets paid more. And so I think that it's important to enable that, and we also have an aging population in America, and so we are going to be calling on younger workers to be able to produce more to support that aging population, and automation can help with that, but also recognizing there is disruption in the short term, and I think that's where employers, workers, unions can work productively together to address that.
Okay, a couple of quick things here. Mr. Corcoran, I'm interested, are you in support of President Trump's tariffs on auto imports?
So there's no doubt that everyone agrees we should make more products in the United States. And how we go about doing that is all up for opinion and stuff. I do know one thing about the tariffs.
Yeah, can just, I mean.
So I'll get
Yeah.
to it. So Volkswagen almost every day talks to us about how the tariffs are hurting them. You know, and okay, I understand it's detrimental to your company to a point, but what are we supposed to do as the worker? Why are you threatening us with?
Okay, well, I need to get another. Also, I know that I looked at your background. You have skilled trades background.
That's correct.
Are illegal immigrants and foreign workers undermining wages of American workers?
Well, as far as you mean, like as far as my job, or as far as what?
Skilled trades, construction, all the different.
I can say that in my line of work, I don't see it. I don't see
Okay.
immigrants coming.
And
to our
then,
job
and then
thinking
finally,
about
I just want to close with this, Mr. Chairman. One of the things I'm concerned about, you heard Mr. O'Brien talk about how UPS pays part-time workers healthcare benefits and through the negotiations and pensions. We have some companies that are offloading their healthcare costs in this country to the American taxpayer because many of their workers are on Medicaid. That is undermining the country, and hopefully we can talk about that another time. Thank you.
Thank you. Senator Blunt, Rochester.
Thank you, Mr. Chairman. Colleagues, yesterday I saw a split screen on the news. Coverage of committee hearings and a shutdown clock. It was a tale of two realities. Republicans continue to call committee hearings like it's business as usual, while Americans are literally living in the midst of a shutdown that jeopardizes their health care, their jobs, and services Americans rely on. Now, the issues here are very important, but the number one issue right now, the number one priority in this moment should be reopening the government and restoring people's health care. So today, I want to use my time to remind us all what's at stake. We are in a pivotal moment. Energy costs are up, the price of food is up, the rent has gone up for many, and millions of Americans in red states and blue states alike are on the brink of their health care costs doubling or losing their health care altogether. From small businesses to farmers, to ranchers, to moms and dads. At this very moment, Americans across our nation are making difficult decisions about how to make ends meet. We can fix this, but it requires negotiations. It requires us to do our jobs and to find a path forward together. We can reopen the government, we can restore health care for millions of Americans who are counting on us, but it requires urgency, it requires trust, and it requires a willingness to come to the table now. My Republican colleagues control the White House, the House, and the Senate. The ball is in your court. Let's make a deal. Thank you, I yield back.
I will note that if we just continue the CR for 7 weeks, we could continue negotiations, and Republicans have consistently done that. With that, I recognize Senator Murkowski.
Thank you, Mr. Chairman, and thank you for the opportunity to have a conversation here with some folks on labor policies. I like the hearing title, Diagnosing the Issues and Exploring the Current Proposals. So we've heard several members here talk about current proposals that they have out there. I think that that's good, but I think it's always good to make sure that the proposals that we have are in response to really a fair diagnosis of the issues. And so my questions are probably going to be a little bit more general. I'm going to start with you, Mr. O'Brien. Thank you for being here today. I just have to say for the record, we really appreciate working with Gary Dixon up north. He's doing a good job for Teamsters 959 up there. So know that you're well represented up there. But we're hearing some concerns about how we as a state really move forward with embracing the opportunities that we have in front of us, whether it's resource development or whether it is just continuing on the initiatives that we've been working on for so long. But our challenges are pretty basic. It's workforce. When you're in a smaller state, when you're a rural state, you got challenges there, right? It's more than basic. I go in and meet with our labor unions, and I'm prepared to be talking about things like the PRO Act, and we end up talking about childcare. The challenges, the difficulty of getting a CDL in rural areas where they don't have the training programs. You've got to go to Anchorage or somewhere else, and it's literally a disqualifier for some of these things. So one of the things that we have, I think, done well in Alaska is tried to be collaborative when it comes to, for instance, the workforce development and training. We've had good, strong partnerships when we're looking specifically to our oil and gas industry. We have a pipeline training center there in Fairbanks that is a facility that has brought together leaders from construction, from oil and gas, from Teamsters. We got our laborers there, plumbers and pipe fitters, operating engineers, IBEW, got everybody. It's not this territorial, this is ours, this is yours, this is the broader Alaska community. So I'll just put a general question to you, Mr. O'Brien, as to any ideas that you might have as to how we incentivize more of these joint training collaborations between industry and labor groups. I think we're doing a good job in Alaska, but how do we replicate that in other areas?
Well, I think as a nation, we would agree that collaboration is important to actually effectuate change. And regardless if we agree or disagree on something, collaboration has to be the key to get programs like you're talking about in Alaska implemented in other states that may need them. We need to be committed equally on both sides to make investments in workforce training that can supplement some of these well-needed training facilities that you describe in Alaska. We need to make investments in CDL training so that we can qualify people that may lose a job because of AI or the implementation of technology. But we also, to support a lot of these programs, I think we need to have conversations with the people that are designing and implementing technologies that may eliminate jobs, that there's a mechanism to require them to fund job training in other industries so that we can transition those people that are affected by the implementation of technology or AI to transition to other careers where they can sustain a middle-class living and provide for their families. So I think accountability is important, collaboration, having conversation, and having a direction to take care of the American workforce in situations like that.
You got any good ideas on how we might address the child care issue, which is keeping good folks from participating?
Well, I think
And
you can.
I guess
I think you can see why it's important.
I want to make sure that it's understood how important.
It's extremely
It's
important.
not something that we generally talk about when we're talking about labor issues, and yet if you can't get
Well, I
folks to
think
programs.
what's important about childcare is, I think we recognize, my generation, my dad was working 15 hours, 12, 15 hours a day in a middle-class job, which allowed my mother to stay home so there weren't childcare issues. I think we've got to find a way, and I think the Faster Labor Contracts Act, which would mandate a quicker resolution to a collective bargaining agreement that would provide higher wages and better benefits, would be part of a solution to a problem that would not require two incomes in a home or two parents to be working. So that could be a solution to the child care issue as well.
Thank you. Thank you, Mr. Chairman.
Thanks so much, Mr. Chair. You know, it's impossible for me to jump into questions regarding labor law without first acknowledging that this administration is now, in this moment, actively working to subvert labor law in our country and has actively created a massive crisis for hundreds of thousands of workers in my state and across the country. I am a senator in my home to the people of the state of Maryland, where we are the proud home of 494,000 federal workers and contractors. Today, we are in day 8 of a government shutdown, a shutdown that impacts each of these constituents. And let's just speak plain language. My colleagues have the keys to the kingdom. They have control of the White House, the Senate, and the United States House of Representatives. And so they are in control. And their refusal to come to the table in good faith and negotiate a plan that both keeps the government open and makes sure that health care is affordable and accessible is an abdication of duty. So many Marylanders would like to show up to work today and serve the American people, but have been left behind by this administration. Hundreds of thousands of civil servants have been either furloughed or are forced to work without pay, all because this president has decided to shut down the government. These dedicated workers, whether deemed essential or furloughed, are legally entitled to back pay at the end of this shutdown. And yet the Office of Management and Budget, headed by the, I would say, very sinister Russell Vogt, has used this Republican shutdown as an opportunity for open and blatant worker retaliation. Right before the shutdown, the same guy, Vogt, first said that he wanted workers and federal employees to feel so traumatized, this is his quote, that they would not want to come to work each day. He also instructed agencies to use a shutdown as an opportunity to issue permanent government layoffs. And just yesterday, reports surfaced that this same guy, Vogt, is now circulating a memo that would seem to challenge the legality of furloughed workers receiving back pay. And this is the same law that President Trump signed, and he said that he would refuse them pay. So, Mr. Abruzzo, I'd like to ask, you are a dedicated career professional who has defended workers' rights and protections under the law. Under the National Labor Relations Act, is it illegal for an employer to threaten employees with a loss of pay to coerce them during a lawful labor dispute?
Thank you for the question, and yes, it is, and I so appreciate you raising this issue because federal employees are the backbone of our government. They keep our workplaces safe, our food safe, our airspace safe, and they don't deserve this. They didn't ask for this, and they should not be bargaining chips in negotiations. As you correctly noted, this is a bullying tactic. Unfortunately, this is not the first time that the administration has inflicted trauma on these dedicated workers. And the president knows better. As you said, he signed the law in 2019. that provides for back pay for these furloughed workers who, I'm just reminding you, did not ask for this and want to get back to work.
Thank you. And you know, I want to use that same standard to illustrate, again, what's happening now. Let's make the point finer. Federal workers who are being prevented from working, they're locked out of their jobs. As you've mentioned, we're not imagining that this was done by design. This guy, Russell Vogt, said it out of his mouth, that it is his intention to make sure people feel too traumatized to come to work. And so this is intended to hurt my constituents. And I'd like to ask you, you know, what does it mean as the former NLRB General Counsel, Mr. Abruzzo, would you tell me what it means to cripple the investigative and enforcement functions of the NLRB, what it means for workers across the country?
Yeah, it means that the system is rigged against workers and they can't exercise their congressionally mandated rights to organize, unionize, and collectively bargain in order to get a fair share of what they deserve. And it is just enabling law-breaking activity.
And so just to be clear, and I just have a few seconds left here, the Department of Labor has furloughed over 76% of its staff, leaving a skeleton staff to keep American workers safe and protect their civil rights in the workplace. And just 24% of OSHA staff are working without pay. Just 10 employees are working at the wage and hour division, the division charged in part with preventing child labor. All 10 are working without pay. So this is a horrible mess. And I want to just leave with a quote of President Trump, who once looked into the camera and told us the following, and I quote, "If the government shuts down, I think the president would be blamed, and rightfully so." This shutdown lands at his feet. Thank you.
For the record, if Senator Schumer would agree to reopen, it could reopen tomorrow. Next is Senator Moody.
I feel like we have to address all of the comments that have been made, but especially the last entire amount of time that was designed to suggest that this is a shutdown on anyone's watch other than the Democrats. And we cannot let that go unanswered. And I agree with Ms. Abruzzo that this is a system designed against workers in the sense that this whole design of this shutdown, led by Shutdown Schumer and these Democrats that won't just keep the funding going for a few weeks while we can figure out next year's spending, it is their design to blame it on President Trump, to blame it on the Republicans, but it is in fact the Democrats who have decided not to continue funding. So they have to spend an entire time, when I really want to get to bipartisan solutions for labor. I was very excited. I have all these suggestions, especially Florida. I feel like we've done a lot of things right for workers. You cannot have somebody sit here and put in front of the American people that the government is shut down because of President Trump or because of the Republicans. It is on the backs of the Democrats, who we've given them time and time again the opportunity to show up and vote yes, let's keep the government open so we can engage in these bipartisan conversations. As someone whose oldest boy is in the Army, as someone who understands that people are facing not getting paychecks, and I think we just heard 5 minutes of comments on this rather than getting to bipartisan solutions on labor, because someone comes from a state where they have a lot of people that are employed by the federal government, and they, by golly, need to blame it on someone else besides the Democrats that are not showing up and voting to open this government. And it makes me incredibly sad, because we have really hardworking people in this country that are not going to get their paycheck very soon. And so I appreciate you letting me indulge in correcting the record, because we are here to do important work. This president, more than any president in my memory, has said, how can we come together in a way that is pro-worker and pro-business, American business, and do right, and focus on how we can maybe tweak our laws to have a better system in place. I'm all about that. And I appreciate you, sir, for coming in here today and saying, I've asked my members, let's come at this from a politically blind way. Who are the best people and what are the best policies that we can push forward in this new age of America, the golden age of America, where we're focusing not on how do we ensure strong free markets, less red tape, better ability to build businesses, can support our workers and our families, and also have a strong backbone to support those business and our American workers. So thank you for saying that. I took note of that, and I thought that was especially useful. I want to start with employee stock option plans. And I want to turn to you, Mr. O'Brien. Have you found, or have you ever been in negotiations where focusing on how employees might be given the opportunity to be owners in the businesses help alleviate some of the negotiation strife or even mitigate strikes?
My experience, and there are stockholders in businesses, but that, in my experience, hasn't had an impact one way or the other on what a employee feels because he may be a stock owner of that particular business. Not my experience has been most of my members are always concerned about earning a livable wage, affordable health care, and negotiating pensions that they know that they'll be able to retire on with dignity and respect. My experience also in situations where you have employers that don't want to agree to retirement plans or any type of retirement outside of 401k, my experience has always been when you look at the demographics of a 401k versus a pension, a 401k is usually taking money out of your own pocket, investing in a retirement plan. If you're lucky, employer may or may not make contributions to match that, but
So
it's
you
no
haven't
guarantee.
seen that be helpful in negotiations?
No, I have
want to
not.
turn to you,
I
Ms.
have not.
Gessler. Have you seen that? And I'm sorry to cut
Yes.
you off. I just want to make sure I have time for
And I
this
think
answer.
at its core, this is a great way to empower workers, and it's a way that recognizes that employees and employers are in business together. And so when the company profits, the workers profit. And that's a great way to recognize that and to have those individuals, the workers, have a stake in the company.
And I'm out of time. I had a million bipartisan issues I wanted to discuss. I just want to thank each of you for being here today. This is a great panel, and Chairman Cassidy, I commend you, sir. I know I'm over my time, but let me compliment you.
You can go over your time to do that.
I knew it. But bringing together people who have different backgrounds and generally come at it from a different place and the stakeholders they're representing, I think this is a great way for us to actually focus on legislation that has a chance of passing. And I was excited to be here today, and I wanted to thank all of the witnesses. Thank you so much.
Thank you. Senator Baldwin.
Thank you, Mr. Chairman. Before I begin with questioning, I ask unanimous consent to enter into the record 4 letters, respectively, from the AFL-CIO, the United Steelworkers, the American Federation of County and Municipal Employees, the American Federation of Teachers, in support of strong labor law reform, including the PRO Act and Public Service Freedom to Negotiate Act, and a letter and a report from the UAW detailing organizing and bargaining efforts at Volkswagen.
Without objection.
Thank you. And on that topic, I want to turn to Mr. Cochran. Thank you for being here today to share your experience, both in your efforts to get the company to come to a contract and come to negotiations, but also your experience on the factory floor. Your testimony highlights that forming a union is often just the first step in the fight for rights and fair treatment and dignity at the workplace. And when employers refuse to bargain in good faith, workers are forced to consider dire options like strikes. And right now, the cards are stacked against workers when they use these tools as a last resort. Employers can and often do cut striking workers' health care to force them to end a strike, rather than negotiate in good faith. I have a bill, Striking and Locked Out Workers Health Care Protection Act, which would create a separate unfair labor practice category for when workers or employers cut or alter workers' health insurance while they are on strike or locked out. Can you talk about how this bill would help workers fighting for a fair contract?
Thank you very much for the question. It's kind of interesting bringing that topic up. Volkswagen has actually used that topic to threaten workers not to be in favor of a strike, that your health benefits will go away. So if something like that was on a law that they couldn't, that takes away a lot of the pressure put back on the members who want to strike. It just gives them an opportunity not to fear that anymore. You know, it's a good thing that the United Auto Workers picks up the health care for the striking workers themselves. We're very grateful for that. But there's a lot of union workers or non-union workers who want to strike that just don't have that option. With that being in place, it would take a huge power away from the company of the threat of you're losing your health care if you do decide to stand up for your rights and lawfully strike.
Thank you. Ms. Abruzzo, I had intended to ask you to go a little bit more deeply into the consequence of understaffing and underfunding activities at the NLRB. Senator Kim kind of gave you an opportunity to expand upon your opening testimony on that matter. So I want to talk more about the independence of the NLRB. You served as NLRB's general counsel, where you supported the mission of NLRB and helped maintain the board's independence. An independent NLRB is critical to enforcing the National Labor Relations Act and upholding the rights of workers. During this administration, we are seeing the NLRB's independence threatened with the unlawful firing of board member Wilcox and executive orders that assert control over the independent agency's operations. So I have a few questions for you to paint a picture of how an NLRB that is independent should operate. If the White House had attempted to influence your prosecution of an unfair labor practice case, what would you have done?
I would not have allowed the White House to influence any of my decision-making.
As an independent agency, should the NLRB ever be following White House orders instead of the law?
Not when it comes to the case precedent.
If the White House is trying to influence NLRB decision-making, do you think that is something that should be reported to Congress?
Absolutely, it is an independent federal agency, and Congress needs to know if the White House is trying to influence the decision makers.
Thank you.
Senator Mullins.
Thank you, Mr. Chairman. And I guess everybody's surprised to see Sean and I on the same page, considering the last time we were in this hearing room. And Sean, I'd like to welcome you back to committee and call you my friend. We talk all the time. We don't agree on every issue, but I think underneath the leadership of President Trump and our common love for those that work in the labor industry, we found quite a friendship. And so welcome back. A couple things that I want to say. First of all, you know, we've heard our Democrats come in and with their talking points about the shutdown. I just want to remind that every one of those Democrats that spoke today about the shutdown, every one of them voted for this exact same CR with the exact same language, with the exact same numbers a year ago to keep the government open. Every one of those Democrats that spoke about it today also voted for it in December. Most of them voted for it in January, and 10 of them voted for it in March. So for them to sit there and say that it's blamed on anybody else but themselves is a lie, because the fact is they elected Chuck Schumer to be their leader, and he's the one that is running scared of his election of AOC not until 2028. He's the one that got chastised in March by her, and all of a sudden his attitude about shutting down the government's changed. So if he would just simply release his members, all those federal employees that they're concerned about could easily go back to work, because they know as good as anybody else, when they chose to shut down the government, they gave the power to the President of the United States during a shutdown, the authority to deem employees essential and non-essential. It's his discretion. So if they really are concerned about the employees, open the government back up. In fact, we're going to be voting again today on a CR, isn't that right, Chairman? That they could open the government up today, and we could just simply go right on with business. One thing I want to state too, I got all the respect for my colleague from Missouri, but I just want to talk about the labor, just to set the standard. I'm not saying it's right, wrong, or either. I just want to make sure that it was understood. He talked about the average Amazon employees' labor around the world being 36,000. Just for statistic purposes that people understand, that's for the world. There's different labor rates, obviously, in different countries, especially third world countries, than there is inside the United States. Inside the United States, the average Amazon employee, when they start on probation, is somewhere between $55,000 and $60,000. The average employee that has any sense of tenure once they're off probation is somewhere between $75,000 and $177,000, depending on their bonus structure and their skill set. So just understand that I'm not trying to get into negotiations on the labor or anything like that. I just want to make sure that the record is set straight on that. Mr. O'Brien, I would like to partner with you because you represent the largest labor force in the country. And we have a national security issue right now, and that's with shipbuilding. I don't think there's another person that can speak on labor statistics with more labor authority than you, and I mean that sincerely. But we need help with the labor force, and we need to be focused on national security for shipbuilding, and we need to enter into a private-public partnership. We've got shipyards that are vacant, that used to build ships. And a lot of it's been shut down because of very liberal states, for instance, like California. And we feel like the labor could possibly help us get those shipyards back up and running. But we need the labor to do it too. So not only do we need help putting pressure on these states to get these shipyards back up and working, but we also need help then staffing them. The skilled labor set that the unions can bring, especially in shipyards, know their place, we can find it. There's not a workforce like that either. But we also need to have the contracts in place that look at it from a national security perspective. And so while we have worked together on several issues since the last time we talked, I would love to dig down on this issue with you more and figure out how we can do something great for not just the workers, but for our nation too.
Well, yeah, I mean, it's a great segue into a conversation about bringing industry back into the United States. And I think shipbuilding at one point in time was a great economic generator for this country. It provided great opportunity for workers. It provided great futures for families. And I think if you ask the majority of people that once came from that industry or a generation who were connected to that industry, it's a very noble profession. And I agree with you. We should be building ships in the United States to avoid any type of breach of security issues in this country. I sit on the Port Authority Board, longest sitting member. I have helped negotiate expansion of ports and businesses on those ports, so I would welcome a conversation how we bring industry, but also train this next generation of workers to successfully build the best ships in the world.
Well, then let's work together. And since the last time I asked you to stand up, I'm going to ask you to stand up this time, shake hands, and we'll just agree to work together.
Yeah, I just wanted, for the record, I'm not a hugger, but I'll shake your hand.
Fair enough. Thank you.
Thank you.
Senator Banks is on his way. I had a couple questions at the end, which I will take the privilege of taking now. I ask for unanimous consent to enter several letters and studies into the record pertaining to the issues discussed today from the National Federation of Independent Business, the National Association of Wholesale Distributors, the Mercatus Center, the HR Policy Association, the National Retail Federation, the Coalition for a Democratic Workplace, and the Associated Builders and Contractors. Without objection, they're entered into the record. Next, I'll ask a couple more questions of you, Mr. Kaplan. The PRO Act and the Faster Labor Contracts Acts identify the time to first contract as a key issue. These bills seek to address this issue by mandating mediation and arbitration through the Federal Mediation and Conciliation Service, the FMCS. Do you agree with this approach? And why does the National Labor Relations Act currently not arbitration and rely instead upon voluntary agreements between unions and employers?
Thank you. I think it's inherent in the act in that the employees are choosing who is going to represent them and make the decisions for them. It is not a third party. So employees choose who represents them in these negotiations. Same thing with the employer. The employer chooses their terms. They are in the best knowledge to make decisions regarding what they can afford, what is best for the economy, and what's best for their business. FMCS, well, I would start by saying I don't know that they have the personnel that would be necessary to be able to meet these demands. But further, there's been a number of individuals who have expressed concern with putting a government in charge of determining the terms of the collective bargaining agreement, and have raised serious questions about the constitutionality of directing terms in a collective bargaining agreement, such as simple as has been talked about here, posting a notice in a workplace as possibly running afoul of the takings clause, limitations on what employees or employers can say, which is a violation of the constitutional freedom of speech, et cetera. And while I'm not an expert in constitutional law, my time on the board in a number of cases only highlighted for me the care that we should take when we start embarking on things that could potentially raise constitutional or legal concerns in those areas.
Is there any mechanism under the FLCA to give workers the opportunity to review or reject a contract that they do not want?
There is not.
Okay. Senator Markey.
Thank you, Mr. President, Mr. Chairman. Mr. President, as you well know, in their blind pursuit of profit, Amazon has perfected a punishing quota system that pushes workers to and beyond their physical limits. They use dystopian surveillance technology to monitor workers' every move. They set requirements for how many packages workers have to move per hour without telling workers what those requirements are. They pit workers against each other in a race against an invisible clock. Then they fire workers who fail to win their impossible game. These high-tech quota systems are shrouded in secrecy and enforced punitively, creating a culture of fear that leads workers to break their own backs to try to keep their paycheck, make rent, put food on the table, or to fill a prescription. We know that corporate bosses will never police corporate greed, and that's why I, alongside the Teamsters and Senator Hawley and labor unions and workers around the country, are championing a bold, bipartisan, bicameral Warehouse Worker Protection Act. That Warehouse Worker Protection Act would ban the most dangerous quotas that plague warehouses. It would require transparency for workers and for those companies that refuse to comply. This bill allows the Department of Labor to hold companies to accountability with investigations and substantial penalties. In short, the Warehouse Worker Protection Act says that injuries are not just the cost of doing business. The cost of doing business in this country is guaranteeing worker safety, worker dignity. Mr. O'Brien, what are you seeing in Amazon warehouses related to speed quotas, technology, and health and safety and their impact on workers?
Well, first and foremost, I applaud the bipartisan effort to try and make sure that our warehouse workers, whether they're unionized or non-unionized, are able to attain productivity standards, achieve health in the workplace. What do I see at Amazon? And I stated this earlier, I see 150% turnover ratio because the quotas, which are not transparent and equally implemented across the board, is promoting a workforce that is recycling continuously. There's no continuity of the workforce. They've got the highest injury rates, highest violations at OSHA. And, you know, I think it's important to recognize, not just at Amazon, but in the warehouse industry as a whole, we got to not forget probably the most difficult times this country ever faced was during COVID. And during COVID, I represent many, many workers who work in the warehouse industry, who work with total disregard, who are deemed essential, just like the Amazon workers, like the UPS workers, and like many other grocery warehouse workers that were deemed essential workers. And they went to work every single day, and they went to work, provided goods and services to this country with total disregard for the health and safety of themselves and their families. So we can't neglect the fact that these are essential workers that need to be protected, not just during COVID, but beyond COVID. And I think it's important to recognize that we have a company that does the same exact work under contract, United Parcel Service and DHL. And through a collective bargaining agreement, we sit down, negotiate terms and conditions, we negotiate safety, we negotiate productivity standards. And if you look at the comparison to a unionized workforce that does the same work as Amazon, as UPS, you will see that when there is not transparency in any industry, especially productivity standards, there's going to be high turnover, higher injury rates, and not consistency of the workforce.
So thank you, Mr. President. My father was a union leader. He lost a finger in a warehouse when he was a young man, before OSHA. He used to use another finger to describe that company in terms of their disregard for his safety. But that's what's happening now with AI. The very humanity of these workers now is being lost. And we have to make sure that it gets protected. And thank you, and the Teamsters, Mr. President, for your work on it. And Mr. Cochran, the warehouse industry is leading the pack on supercharged injury rates and work speed quotas, but corporate greed doesn't discriminate. Auto industry bosses also forsake workers' dignity just to pad their own pockets. What are you and your co-workers experiencing in Chattanooga?
So thank you for the question. As far as dignity in the workplace, we actually asked them to sign a thing saying they would, every worker would have dignity and all this stuff. They refused to bargain with us on that, refused to even sign the memorandum of understanding about that. One of the things we struggle with mostly is about bathroom breaks. So we have 10 minutes to use the bathroom every 2 hours. Not everybody has to go to the bathroom at the same time. People need to go maybe between those times. It's very, very seldom they get relieved from the line to go do this. We had an incident where actually one of our members actually relieved themselves while on the production line. And then they were actually refused to go clean up. You have to wait till your break time, wait till your lunch or whatever it is. It's an extreme case, but year after year, we've talked to Volkswagen about this very topic, and it's still a topic of concern while we're going through bargaining. They shouldn't be allowed to come to our country and just break our labor laws and treat our people the way they do. It's unfair to the workers.
Thank you for what the UAW is doing. Thank you for what the Teamsters are doing. Thank you for the union movement. Thank you. Mr. Chairman.
Thank you. I yield 5 minutes to myself for questions. Mr. O'Brien, you wrote an op-ed in January about how some companies abuse the H-1B visa program, and I want to read part of it. You wrote that, quote, not content with shipping jobs to India or China, corporatists have found a way to control their subjects right here in America. H-1B is a way for employers to hurt the American workforce and make foreign workers their serfs. Mr. O'Brien, how are corporations abusing our immigration system to bring cheap labor here?
Well, I think, namely, the HB1 guest visas were supposed to be used to hire foreign workers with very unique skills that could not be found in the U.S. And like anything else, you know, those employers expanded the programs and started expanding that to workers from distressed countries, bringing them over, paying them far less, and exploiting them. That was not the intent. The intent was to bring workers over here that had a unique skill set that could be utilized in certain circumstances, you know, and we've even seen in some cases where employers have brought these folks over from foreign countries with no unique skill set, but they taught them English. And that's not part of the program, and that's not the way the program should be. Employers should be mandated to invest in American workers, and if the skills aren't here, allow the opportunity for people to come over for a short period of time and teach those skills to our American workers. And you know, the thing that's missing in this whole conversation, and I'm a product of immigration, I think all of us are, and I embrace immigrant workers, but the reality of it, the burden keeps getting pushed on the workers, on the unions that represent undocumented workers or the unions that represent illegal aliens or however they're classified. But there's no discussion and or consequences for the employers that hire and exploit these workers. That's the troubling part for people like myself.
Yeah, I totally agree. You titled your op-ed, Why H-1B is Wrong for American Workers. I want to talk more about that and ask you, why is the H-1B visa system wrong for our American workers, and what should we do about it?
Well, we have such a talent pool in this country, And we should be utilizing and investing in that talent pool and train Americans to do these jobs. You know, it's unfortunate when you, and I read this the other day and it caught my eye. We are American. And in too many situations, we're Americant. And this is one situation that demonstrates where we take that Americant approach, bring people over to do jobs that we have plenty of people that are qualified, willing, and able to do for higher wages and better benefits.
Yeah, totally agree. I just introduced legislation to reform the H-1B program. H-1B visas, as you've already said, were supposed to only be for the best and the brightest foreign workers in high-skilled occupations when American workers aren't available first. Here are some of the recent H-1B visas granted in the last 4 years. A landscape architect with a salary of $36,000, that was one of them. A squash professional with a salary of $50,000. A substitute teacher with a salary of $20,000. How can we work together to stop H-1B visas from being used to replace American workers?
Well, I think we've got to hold these employers accountable and make certain that there are stiff penalties for the exploitation and the pandemic in this situation of liabilities when they're not telling the truth. I mean, we have the best colleges and universities in the world in this country. And you use the example of a substitute teacher at $20,000 per year. We don't have people coming out of colleges and universities in America that are qualified to teach?
We obviously do. The H-1B program isn't the full story. Nearly half as many workers are here via the Optional Training Program, OPT, which doesn't have any caps or wage limits. What more needs to be done to reform the immigration system so that our American workers like your members come first?
Well, it's got to be full transparency and accountability for those programs. If, like anything else, if people are not being held accountable and there's no checks and balances in place, they're only going to get away with what they're allowed to get away with.
Totally agree with that. I appreciate all of you being here. For any senator wishing to ask additional questions for the record will be due at 5 p.m. Thursday, October 23rd. Thank you to all of our witnesses for your testimony today. The committee stands adjourned.